Excited Utterance, the Evidence and Proof Podcast, Episode 166, Daniel Medwed, Secrets of Chambers. Welcome to Excited Utterance. I'm your host, Ed Cheng from Vanderbilt Law School. Excited Utterance is your podcast for cutting-edge scholarship and developments in the world of evidence. We bring virtual workshops to you throughout the academic year. This week, our guest is Dan Medwed. Dan is University Distinguished Professor of Law and Criminal Justice at Northeastern University. Dan works broadly in the areas of criminal law, criminal procedure, and evidence, and has often focused on the problem of wrongful convictions. Our podcast today features Dan's new article, Secrets of Chambers, the Constitutional Right to Present a Defense at Middle Age. It was published last year in the Arizona Law Review. In it, Dan discusses the past, present, and future of Chambers v. Mississippi, the classic case that established a defendant's constitutional right to present a defense, even in the face of well-established evidentiary rules. Chambers is often thought of as a constitutional safety valve on the rules of evidence. If you might state it broadly, if a defendant really needs a piece of evidence, a factor that is usually known as criticality, and that piece of evidence has indications of trustworthiness, often shortened to reliability, then a criminal defendant has a constitutional right to present that evidence. It's a pretty remarkable rule, but how has Chambers held up over the last 50 years? And what might the current court do with the doctrine? My discussion with Dan delves into these questions. Dan, delighted to have you on Excited Utterance. Welcome.
Ed, thank you. It goes without saying, I am excited to make some utterances. Thank you for having me.
So the primary focus of your article is this classic case, Chambers v. Mississippi, what I think some might call an oldie but a goodie. If you can just bring everyone up to speed, can you do just a brief recap of the case?
Sure. Thanks, Ed. So going back to 1969 in the Deep South, of course, a hotbed of racial tension, some police were executing an arrest warrant at a local pool hall, and a melee ensued. No one wanted to turn over the subject of the arrest warrant, who happened to be a young Black man. And the result of this brawl was that an officer was shot and killed. And get this, Ed, his name was Officer Liberty. Officer Liberty was shot and killed in this Mississippi pool hall. And the original suspect was a man named Leon Chambers, a Black man who had no criminal record. He was a deacon in the church, but the evidence against him consisted essentially of eyewitness testimony. One person claimed to have seen him shoot at Officer Liberty. Another person saw his arm cocked or in the position as if you're about to shoot him. So Chambers is arrested and charged with the murder of a local police officer, Officer Liberty. As the case is wending its way toward trial, rumors started to evolve that another man named Gable McDonald, a young Black man in Woodville, had committed the crime. Essentially, he told three friends that Chambers was taking the fall for a crime that he had committed, and that he had a .22 gun, which was the caliber of the bullet that killed the officer, and that he had disposed of it and fled to another jurisdiction. Later, he made a confession to a local man, sort of a community leader. He confessed the crime. And he later repudiated that confession in a formal process. So case goes to trial against Leon Chambers. The defense actually did a pretty good job, Ed. They wanted to develop the argument that Chambers was innocent, that the government couldn't prove his guilt beyond a reasonable doubt. So first, with respect to the reasonable doubt argument, they brought in some witnesses, other eyewitnesses, to say it wasn't Chambers. One person testified that he was watching Chambers throughout this altercation. Chambers didn't fire a gun whatsoever. The second part of their defense was Chambers is innocent. This guy, McDonald, did it. And here's where things got interesting from an evidence issue. The defense tried to call Chambers as an adverse witness, a hostile witness, but the court refused to allow that. So essentially, the defense was required to call him as a regular witness. And on direct examination of this guy, McDonald, they elicited that he had confessed to this crime, but that he later had recanted, he had repudiated it. And then on cross-examination, the government really rehabilitated him. Because of a rule in Mississippi called the party voucher rule, that back then said you could not impeach your own witness, which is not the case in the federal system now or in the vast majority of states. You're allowed to impeach anybody, as we well know. Because of that rule in Mississippi, there was no redirect. And the defense didn't have an opportunity to get that last word and really eviscerate McDonald. Second, the defense wanted to introduce the fact that McDonald had confessed this crime to three other people, to three friends. And under the federal rules and the rules of most states, Ed, as you know incredibly well, that might be a statement against your penal interest. You're a third party, you confess to having committed a crime, and then the person who's being charged with it will try to bring in that statement against the declarant's penal interest, subject to corroboration rules and various other rules. But get this, Mississippi back then in 1969 followed the old common law rule regarding the statement against interest exception, which was limited to just statements against your proprietary or pecuniary interest, not your penal interest. So Chambers was barred from introducing evidence of those three confessions by McDonald, and the jury was left with the impression that Chambers committed the crime. So Chambers was convicted of murder, sentenced to life in prison, not the death penalty, which might be a sign of how everyone viewed this case at the time, and he was sent to the notorious Parchman prison. Case goes up to the US Supreme Court, and in an opinion authored by Powell, Justice Powell reversed. And he acknowledged that sometimes the rules of evidence need to fall in the face of constitutional considerations. Either under due process or compulsory process, the Chambers case set up a test known as the constitutional right to present a defense. If a defendant wants to introduce evidence in his favor, and the rules of evidence preclude him from doing so, if that evidence has both persuasive assurances of trustworthiness, it's incredibly reliable, and is critical to the defense, then it could be reversible error. Supreme Court reversed the case, and Leon Chambers was freed. And we had this new doctrine in 1973 known as the constitutional right to present a defense. A little longer than you probably wanted, Ed. Sorry.
Yeah, but that is the whole story. Now, I think we should emphasize that although both of the rules that were featured in Mississippi at the time that you talked about, the voucher rule and the way that the statement against interest exception was constructed, even though both of those now are seemingly archaic and rejected today, both were pretty standard fare under the common law, right? So Chambers was in effect going out on a limb in some ways, saying, we don't really like these rules.
Exactly right. He was going out on a limb. And what was interesting, it put the Supreme Court in a little bit of a conundrum because at that point, there was some relatively well-developed case law about compulsory process, the idea that you have a constitutional right to call witnesses in your favor. And if there's a state law, like a state law of evidence, that is so much of an outlier, that is so arbitrary, then it could violate the compulsory process clause. And it stems from a case called Washington versus Texas from 1967. But this case wasn't a perfect fit for the compulsory process doctrine, Ed, for the reasons you just identified. The voucher rule wasn't an outlier. The statement against interest rule wasn't an outlier. So Justice Powell sort of had to create this new-ish doctrine, constitutional right to present a defense, and grounded it more in due process than compulsory process, which might have felt like a better fit.
And you actually talk about this in the paper as well. So you're saying that Powell, because he was in a bind, creates Chambers as a bit of, I don't know whether it's the best way to describe it as a double-edged sword, but in some ways it's super bold, but at the same time, it comes at a price. So talk a little bit about that trade-off that Justice Powell had to make.
I love that. I think you're exactly right, Ed. So it ties in a little bit to rules versus standards. It ties in a little bit to having a clear doctrine versus a fact-intensive inquiry. But basically, by making it more of a standard-based decision, that essentially the defendant has to show that this evidence that was suppressed was excluded, has both persuasive assurances of trustworthiness and is critical. It basically gave a lot of wiggle room down the line for judges to reject defendants in this way. Unlike what we've seen, say, in the confrontation clause area, sort of post Crawford, and who knows how long we'll have a Crawford regime in place, where there's a little bit more clarity. There's wiggle room about what is testimonial and what's not, but it's a bit more of a mechanical rule. You can sort of figure out whether something is or is not implicated by our confrontation clause jurisprudence. Powell went the other direction, a much more fact and circumstances, case specific inquiry that I like your analogy at. It really is a little bit of a double-edged sword.
Let me move on from the case itself and talk about the next 50 years. So Chambers was 50 years ago. Where has the case law gone since then?
Well, not as far as some of us would like, or at least as I argue in this paper, Ed. And I'm very curious. I have so much respect for you and your scholarship, what you think on this front. But essentially, and this ties into your last question, because of the fact specific nature of this constitutional right to present a defense, Chambers is often cited, but has seldom resulted in reversals. And because it's so tethered to the facts, it doesn't always lend itself to a case that the Supreme Court would grant cert on, right? There's not often a circuit split on how to interpret it or cases of pressing national significance. So there have been a handful of significant Supreme Court cases, three that I call the trilogy, Green, Crane, and Holmes, which was the most recent big one in 2006. And then there have been a number of other cases. So my research assistants and I did sort of a deep dive into the case law. And we found, thousands of cases that have cited Chambers, but mainly in dicta, unsurprisingly. We found at least 13 federal appellate court reversals on Chambers grounds, and we found 166 state court decisions that analyzed, examined, or discussed Chambers in depth. Some of them, of course, resulting in reversals, many of them resulting in affirmances. So the upshot over the last 50 years is that I think in some ways, Chambers is an underutilized resource for defendants. I should also note that there were some major constraints on our study. You're one of the country's leading empiricists, Ed, so you probably looked at these numbers and started to get sick. But there's a numerator and a denominator problem here because a lot of the appellate decisions only involve preserved issues and are dependent on whether trial lawyers raised Chambers down below. Also, they don't capture how often Chambers came out at trial as an issue, and maybe the defendant won based on a Chambers argument and managed to convince a trial judge to reverse the case. So sort of the takeaway from the last 50 years is Chambers is, in my view, sort of this under-polished gem, or as I said, underutilized resource.
Your empirical critiques of yourself are fair, but I think the outcome or the results that you found are super interesting, but I'm not really sure what to make of them. I've always thought that Chambers was basically a loser argument. Students love to raise these issues on exams. They always throw in Chambers for some reason on my exams. And I always tell them that that's the last ditch effort. Don't go there until you are done with every other plausible argument that you can make. But what you're showing is that even in the published literature, which is going to be a reduction of what you're going to see, you've got some significant number of cases. So it's not as big of a loser as I've always thought. It's actually that courts actually take this relatively seriously.
Ed, I love that observation because I say the same thing to my students. I sometimes call Chambers the constitutional equivalent of the residual exception under Rule 807, right? Like, just, I'm sure students use 807 all the time on exams too. They do for me. And I'm always telling them, guys, 807, it's not just for near misses. It really is for something like Dallas County, right? That novel hearsay issue. So that I have a similar reaction. But you're right. It's a last ditch effort for criminal defendants. And sometimes that last ditch effort unearths something valuable. Just a little bit of backstory here, Ed. The reason I did this project, and I bet you have this too, we all have our little files of ideas for articles that we want to get to at some point. So maybe when you're done with a project, what I'll sometimes do is go through those files and see if anything grabs me. So when I was a public defender, I was an appellate lawyer in New York before becoming an academic, just handling appeals on behalf of indigent criminal defendants. Chambers was my favorite case. And I cited it in every single brief. And it was always in the last point. You always lead with your strongest points and you end with your weakest. It was never a winning argument, but I always felt like, and maybe this was my mentor telling me this, I always felt like if a judge feels like an injustice occurred in the case, and maybe under the rules of evidence or something else, they couldn't reverse the case, Chambers gave them a peg to hang their hat on. And that, in a sense, was its value. Not that it was necessarily under the law a winner, but that as a matter of sort of legal realism, it could be used as a proxy for justice for a judge so inclined.
Interesting way of thinking about it. Now, let me turn to what I guess is the final part of your paper, where you talk about the future of Chambers and where it might go. Chambers is, of course, a right for criminal defendants, and you have a Supreme Court at the moment that is particularly conservative and probably naturally averse, or it would seem naturally averse to a doctrine like that. But you think that Chambers is likely to endure. Now, why is that?
Yes. And so this is my view. And I don't know if you've thought about this, Ed. I'm sure you have because you've thought about everything or talked to other guests about this. But there's a great deal of debate right now, especially on the left, about whether to even seek cert in cases, right? Because of a concern that the conservative bent of the court will create precedent that will be detrimental to criminal defendants or certain civil litigants, right? I'm sure that's something that's come up from time to time. And I think a lot of people in talking to me about Chambers or some of these other constitutional doctrines have suggested, don't go to the Supreme Court. If you have a good decision in the lower courts, just keep it, right? Even if you've lost, don't try to get a cert. And so that led me to think and explore whether or not that was too pessimistic. And so I began to sort of strip away some of the varnish covering Chambers, think a little bit more deeply about why Powell went in this direction and why it was an 8-1 decision. Rehnquist was the only dissent, why it had such a hold on a supermajority of the court. And are some of the arguments underlying it, or are they potentially attractive to the current members of the court?
Yeah, and if I can interrupt you for 1 second, 8-1 in Chambers, but the most recent rendition in Holmes is 9-0 with Alito writing. So you've got effectively a supermajority on the court that likes this doctrine, if not unanimity.
Exactly. And I love that you mentioned that because I remember when Holmes came down, I was actually in my first or second year of teaching evidence in 2006. And I was shocked at that opinion. And especially that Justice Alito had written it. And it gave me a lot of hope, not just for his jurisprudence, but for the direction of this doctrine. That was the last case, but it still gives me some hope. So the doctrines that seem to support it, and I realize I'm on a shaky ground with a couple of them. One is there's a strong libertarian aspect to this decision, which is absolutely protecting the little guy against the awesome power of the state, protecting the little guy against the mechanical application of evidence rules. And if the greater cause of justice should surpass or circumvent the policies underlying these rules, then the greater cause of justice should prevail. And that sort of libertarian argument is something that Justice Gorsuch in particular might find appealing. We've seen that in his jurisprudence in the last 8 years. He's on the bench. The second argument that I tried out, which is the one that's, I think, shakier, is that there isn't an originalist component to the constitutional right to present a defense. At least what Justice Powell did is he tried, as I said, to tether it to due process and to tether it to a bunch of 19th century cases in particular that talked about the right to present a defense, the constitutional right to present a defense, and that in turn cross-referenced cases from ye olde England that sort of stand for this highfalutin concept. Now, these cases didn't often go into detail about the origin of this right and what it really means in practice, but there is an originalist thread that I could pull and that people could pull to support it. The third argument, and I'm very curious what you think about this one, goes back to the rules versus standards debate. So I think it's sometimes simplistic when people talk about political ideology and jurisprudence. Sometimes people will say conservative jurists like rules. They like the certainty of fixed positions, and progressives prefer the malleability of standards. And that seems to be very simplistic, right? Because it all depends on the rule and depends on the standard. So in the paper, I make an argument that Chambers, as we've discussed earlier, Ed, is very much a standard-based principle. And as such, it would appeal based on that sort of binary approach to rules versus standards that I feel is too simplistic. It might appeal to progressives. But I make the argument that in fact, in this situation, the standard-like nature of the rule might appeal to conservatives because they could have this position that aligns with originalism and libertarianism, but they still have the option, because it's a standard, to simply affirm the decision that has potentially been to the detriment of the defendant. And so that maybe it's not sort of a threat to conservative jurisprudence.
So I can see both the libertarian and the originalism thread, and that a lot of that has to do with what the history shows. On the fact specific right, I'm curious, or at least I want to push you a little bit on this. So I think in the paper you talk a little bit about how we live in a very polarized society and that people will feel more comfortable when you have a standard because they, in effect, are able to project their own view of where this will be decided based on it's a standard. So if I were to apply it, it would only be used in the right cases. And my concern here, or at least the thing that strikes me about that, though, is there's something a little contrary to the rule of law in that attitude, which is that the right is only acceptable as long as I can make it say whatever I want on a case by case basis, right? Am I being insufficiently charitable to the doctrine here, or is that actually a problem?
As usual, you're 100% right, Ed. And here's the response. The argument in favor of rules is very much the point you just made, which is certainty aligns with the concept of the rule of law. If the tax code says you have to file your income taxes by April 15th unless you apply for an extension, that creates uniformity for everyone. It creates certainty. That is justice. And that is appealing to many people. Whereas if the tax code said, file your taxes within a reasonable period of time after the end of the calendar year, that would create uncertainty, variability. There'd be an advantage to sort of well-heeled people who could get good lawyers and so on. The reason why I think it might work here is a little bit like the reason why I think the advisory committee embraced Rule 807, the residual exception that we talked about, which is as much as one appreciates and respects and likes certainty, many people also acknowledge that, like all systems devised by humans, errors are inevitable. Problems are inevitable. So we should have potentially some last chance saloon, or as you said before, last ditch opportunity to correct a potential injustice. And part of the rule of law is acknowledging that. Now, that doesn't mean that it's necessarily a great thing because it's going to lead to arbitrary results, potentially capricious results, but that in a system that's imperfect, maybe just having that option is, even if suboptimal, something that we should choose to do. And I think that's where I come down on it. It's this last ditch opportunity to show that even if the rules of evidence were applied properly, as in Chambers, it violates a more fundamental and powerful principle, the right to present a defense. And in this particular instance, we should allow that right to supersede the mechanistic application of the rules.
Well, that's a great note to close on. Dan, really enjoyed the opportunity to talk about Chambers and the future of this right to present a defense. Great having you on the show.
Ed, fantastic. It is so good to see 803 to you. I mean, we have to give some evidence jokes, and the excited utterance one has been overdone, no doubt.
As Dan and I discussed in the interview, Chambers is something of an odd duck. On the one hand, it's a fundamental safety valve for the evidentiary rules. It says that you can't arbitrarily apply the rules to deprive a criminal defendant of the right to present evidence in his own defense. That's fair enough. In fact, Alex Nunn, Julia Simon Kerr, and I have argued elsewhere that the rules of evidence should have this kind of safety valve in all cases and for all parties, not just criminal defendants. If trial is going to be a search for truth, then sometimes these rules need exceptions. But on the other hand, the fact-intensive nature of the Chambers inquiry leads to some concerns about the rule of law, especially if that is the primary reason that political actors find the doctrine tolerable. It's one thing to use a safety valve when there's broad consensus on what evidence should be admissible in spite of the formal rule structure. Take the Chambers case itself. I think most of us would agree that Chambers should have been able to introduce the witnesses that heard McDonald confess to the murder. That seems fundamental, regardless of whether there is a voucher rule or a particular rendition of the statement against interest exception to the hearsay rule. But if the reason why a Chambers right is retained is merely because its fact-intensive nature makes it easily controlled by judges, that strikes me to be, and here I'll flip the famous John Adams quote, that's a nation of men and not a nation of laws. In today's polarized world, if the only rules we can agree on are the ones that we hope to control on a case-by-case basis, that's only going to lead to arbitrary decision-making. This kind of regime will mean that a defendant's rights will depend on who the defendant is and who is on the bench. So, Chambers is perhaps a cautionary tale. It teaches us that we can't rely on a system of rigid rules for justice alone, but at the same time, nor can we rely purely on the discretion of all too human judges. As with many things, it's a balance of these rules and standards, along with a healthy dose of good faith that the judicial system relies upon. Support for Excited Utterance is generously provided by Vanderbilt Law School's Branstetter Litigation and Dispute Resolution Program, as well as the Texas A&M University School of Law. The associate producer is Alex Nunn, and the production editor is Anna Ruth Morella. Additional production assistance is provided by Lizzie Herrera, and background music is provided by Kirsten Castle-Greer, Felix Wong, and Alex Crew. I'm your host, Ed Chang, and I hope you'll join us again next time when we take on another new work in the world of evidence and proof.